Welcome to Chapter 5 on Civil Rights. This is Part 2 and continuation. As we will see, the struggle for civil rights had a long and storied history. In terms of trying to understand, however, though, why for the first 70 years or so of our country, given its size and limited scope of the national government from the founding to the Civil War, meant that the national government was more or less restrained in its willingness and, more importantly, ability to provide rights protection to its citizens. Again, you have to remember that the states were really acting on behalf of the national government in its implementation of the Constitution. Consequently, the states had a certain amount of freedom as to what they could or could not do. In fact, this first one talks about that it didn't use the 14th Amendment passed in 1868, but we're going to talk about a couple other issues before then to provide equal protection clause. In 1866, the Civil Rights Act of 1866 granted citizenship and the same rights enjoyed by white citizens to all male persons in the United States. Ladies, please note the key word there, male persons. It would be another approximately 50 to 70 years before you would get the same rights, without distinction of race or color or previous condition of slavery or involuntary servitude. What's interesting about the wording of this particular act was that President Andrew Jackson's veto of the bill was overturned by 2/3 majority in both houses of the Congress, and the bill actually did become a bill. In 1875, the Civil Rights Act was struck down. This bill was passed. The initial bill was first passed by the last biracial U.S. Congress of the 19th century. The purpose of the Civil Rights Act of 1875 was to provide protection to all Americans regardless of race in their access to public accommodations and facilities such as restaurants, theaters, trains, and other public transportation, and that the protection of this right was to also allow them to serve on juries. However, it was not enforced, and the Supreme Court declared it unconstitutional in 1883. The next federal bill designed to protect civil rights would not become law until 1957, 3/4 of a century after the 1875 Civil Rights Act. So as you can see, that there was a delay, and we're going to next discuss why there was a delay. The delay had to do with states passing what is commonly referred to as Jim Crow laws, which allowed and in some cases actually mandated racial segregation. In Louisiana, a gentleman by the name of Homer Plessy, a black man, boarded a train car reserved for white passengers. Now you have to understand that Plessy was only 1/8 African American. He was held in violation of the Louisiana criminal justice and Jim Crow laws that mandated separation of races on rail cars. Plessy sued, claiming the law violated the 14th Amendment of equal protection rights. The Supreme Court disagreed. Justice Henry Billings Brown wrote in the court's opinion of Plessy versus Ferguson as follows. Laws permit and even require their separation in places where they are liable to be brought into contact do not necessarily imply the inferiority of either race. Thus, we, the court, find the underlying fallacy of the plaintiff's argument to constitute an assumption that enforced separation of the two races stamp the colored race with a badge of inferiority. This would go on to be a very key piece of action by the court and would constitute a policy that most states, particularly southern states, would follow for the next 50+ years. As you can see, the court in its ruling said, as I talked about in terms of discussing Justice Brown's terms, was that it was not, that the 14th Amendment was not intended to abolish the distinction based upon color. This case was then the beginning of what we would see, as I said, of the policy for the next 50+ years of the separate but equal rule that would segregate the races, but allegedly having equal facilities and equal rights. For the most part, the U.S. Supreme Court, for the first century and a half of its existence, was not a particularly proactive type of court. Generally, it was there for cases to be brought to it. It ruled based upon its understanding of the cases. And so consequently, we did not see them becoming that active in equal protection. However, in the 1930s, this would begin to change, even though the rulings continued to enforce rather than strike down this separate but equal. However, it was a reflection of also the court began examining in its nationalization of the Bill of Rights. We can see in 1938, for instance, that the court required admission to a Missouri law school rather than paying for out-of-state tuition for African Americans, and again in 1950 that the Supreme Court rejected the Texas's claim that its new law school for Negroes was equivalent to the all-white University of Texas school. Chief Justice Evan Hughes found his court faced with a number of cases addressing civil liberties during the 1930s. Hughes was a supporter of the new liberalism that was a swing vote for many of the New Deal issues that came before the court. Well, generally most people know of the case of Brown versus the Board of Education. What is interesting that in the state of South Carolina, it was one of the 17 states that required school segregation. And in fact, as you can see, Section 5377 of the Code of Laws read that it was unlawful for pupils of one race to attend the schools provided by the Board of Trustees for persons of another race. This case, Briggs versus Elliott, started here in South Carolina in Clarendon County. And in fact, over the last year, there's been a fair amount of press relating to this, but the history of this case. The case began in 1947 as a request to provide bus transportation. In addition to having separate and very inferior facilities still existing today, black children had to walk to school, sometimes many miles. In a neighboring Jordan community, some children walked as many as 18 miles round trip to school each day, and children had to frequently gather wood for heaters within the schools. School Superintendent Elliott refused, saying black citizens did not pay enough taxes to warrant a bus, and that asking white taxpayers to fund the burden would be unfair. In 1949, the NCACP agreed to provide funding and sponsor a case that would go beyond transportation and asked for equal protection opportunities in Clarendon County. This case, of course, was joined with Brown versus Board of Education, which we'll discuss in the next slide, but it provided only a hollow victory for those associated in Briggs. Most of the people were fired from their positions that they held, some of them with the school district, and or had their houses and churches burned, and most, if not all, moved out of state. The selection of Board versus the Brown, the case of Brown versus the Board of Education, the selection of this case was a key issue. The justice chose this case, even though there were several others that were then merged into the Brown case. It was selected because it was a case from outside the deep South, and the court wanted to send a message that discrimination was a national problem, not just a Southern problem. Again, this is a key move on the part of the courts. It was a part of its activism that we would see continue throughout most of the 20th century. The decision in Brown sent the message that the mere fact of separation or segregation made for equality. In other words, separate but equal was an oxymoron. As we can see, Linda Brown was a third-grade African-American child. Her parents were fairly well-to-do. She attempted to attend a school close to her home, which was for white students only. As you can see, and this is an important piece, is that the ruling of the court basically said, in the field of public education, that separate but equal was no place. We would continue to see still problems in other areas with this separate but equal that would have to be addressed by other means. Of course, there were several problems or issues with the Brown's effect. First was that there was a delay in enforcing it by local officials. Again, states were still very strong on their states' rights issues. Just because the Supreme Court ordered that separate but equal was not to be followed did not mean. The court's action really only addressed this issue of de jure segregation. In other words, legally that the states could not segregate. However, the issue of de facto segregation, in other words, what people thought and felt, continued. However, this point, while left much to desire from a cultural perspective, the decision in Brown did represent a dramatic expansion of federal power to intervene in the regulation of state and local government and even into the private sector. However, as you can see from the third point, as mentioned in the previous slide, it did not address discrimination in employment and voting. Probably the major or the most important point of Brown versus Board of Education was that the Supreme Court finally interpreted the Equal Protection Clause of the 14th Amendment such that it overturned the Plessy decision, arguing that separate facilities are inherently equal. So once the Constitution was reinterpreted under Brown, the national government was able to play a greater role in protecting citizens against racial discrimination. As we can see from this graph, discussing about whether Southern black school children were attending school with whites from 1955 to 1973, we can see that we really don't see any major shifts until the 1960s. So did Brown versus Board of Education desegregate schools? The answer is initially no, eventually yes. And so, as I said, local officials were slow to act based upon the decision of the court. In fact, in 1957, Governor Orville Faubus of Arkansas used his National Guard to block the entry of 9 African American students into Little Rock High School. A month-long confrontation ended when President Eisenhower sent in U.S. troops to escort the students into the high school. Prince Edward County of Virginia closed their schools, turned them over to a private concern who excluded African Americans. This went on for years until the Supreme Court ruled that the transfer of the schools to a private concern were unconstitutional. These are just two of several, actually a number of events that occurred mainly in the South, but were set up to block this desegregation issue. And in fact, some of these issues then helped lead to the Civil Rights Act of 1964. This concludes part 2 of chapter 5. In the next part, part 3, we will begin addressing the rise of the civil rights movement.